Which of the following section was amended by the Information Technology Act 2000? Section 17 of Indian Evidence Act. Under Section 17 of Indian Evidence Act, admission is both written and oral. Admission according to Indian Evidence Act include statement made by expressly referred party, agent of the party to the proceeding authorized to make the statement, person whose liability must be proven, person from whom the party derive his interest in the subject matter. Who can make admission under Indian Evidence Act? A party to proceeding. Under which section of Indian Evidence Act admission is defined under Section 17? The term admission in Indian Evidence Act involves none of these. Give the correct answer. All admission are confession, but all confession are not admission. This statement is incorrect. Admission by agent are admission in civil proceeding only if the agent has authority to make admission, never admissible in criminal proceeding. Admission bind the maker in so far as it reaches to facts. The term admission is defined in Indian Evidence Act 1872 in Section 17. Admission is not a conclusive proof but operate as only as estoppel. Admission means statement suggesting inference as to any fact in issue. If the accused voluntarily consent brain mapping or narco analysis, then such information is relevant under which section of Indian Evidence Act? Section 27. Indian Evidence Act, confession is defined under none of these. What is evidentiary value of admission and estoppel? Admission are not conclusive proof of the matter admitted. Under Indian Evidence Act, which one of the following section define admission? Section 17. Which one of the following provision of Indian Evidence Act define the term admission? Section 17. Which one of the following admission is no evidence? An admission by one of the several defendants in a suit against another defendant. An admission by guardian ad litem against a minor. An admission is a best evidence against the maker of it, either oral, documentary, or contained in electronic form. In which one of the following section of Indian Evidence Act define admission? Section 17. Admission are may operate as estoppel. Which one of the following statement is correct? Admission may be oral, documentary, or contained in electronic form. Which one of the following statement is correct regarding the admission under Section 17 of Indian Evidence Act? It is generally irrelevant as to whom an admission is made. Admission are not conclusive proof. Which statement are admissible? An oral and documentary which is contained in electronic form. Admission must be oral writing or either oral writing. C. Admission can be either formal or informal. Admission is defined under Section 17 of Indian Evidence Act. Under Indian Evidence Act, admission can be made by a party to the suit, a counsel of the party, a person interested in the subject matter. Which one cannot make admission? Admission by co-defendant. Admission under Indian Evidence Act 1872 can be either oral or written. An admission under Section 17 of Indian Evidence Act is an oral documentary statement contained in electronic form. Admission is a statement which is oral, documentary, or contained in electronic form. Which one of the following is irrelevant? Admission made by a person who has not been expressly referred by the party to the suit. The question is whether a horse sold by A to B is sound. A say to B, go and ask C. C know all about it. C statement is an admission. The question is whether the horse sold to A to B is sound. A say to B, go and ask Mr. C. C know all about it. C statement is a admission. The general rule is that admission is provided against the maker. Which provision of Indian Evidence Act provided it exception? Section 21. A is accused of receiving stolen property while knowing them to be stolen. He offered to prove that he refused to sell them below their value. He may be proved an explanatory of conduct influenced by the fact in issue. Which section of Indian Evidence Act laid down the rule of certain circumstances admission can provided by or behalf of the person making it? Section 21. Which section of Indian Evidence Act provided that admission can be proved by or behalf of a person who makes admission? Section 21. A is accused of receiving stolen property knowing them to be stolen. He proved that he refuses to sell them below their value. Which one of the following statement is correct? A may prove the statement through the nature of admission because they are explanatory conduct influenced by the fact in issue. The case of Kashmira Singh versus State of Madhya Pradesh is related to confession of co-accused. Which provision of Indian Evidence Act laid down that rule that in certain circumstances admission can be provided by or behalf of the person making it? Section 21. An admission as a content of electronic record are relevant when the genuineness of electronic record produced in question. Under Indian Evidence Act 1872, the provision of relevancy of oral admission is contained in electronic record is provided under Section 22A of Indian Evidence Act. Oral admission as to the content of electronic record are provided under Indian Evidence Act in Section 22A. Which section of Indian Evidence Act 1872 deal only with civil matter? Section 23. Section 23 of Indian Evidence Act deal with relevancy of admission in civil cases. Which one of the following section of Indian Evidence Act does not deal with the criminal matter? Section 23. Communication are made without prejudice to are protected under Section 23 of Indian Evidence Act. A rustic woman is apprehension of assault and maltreatment makes confession for murder of her mother-in-law in the village panchayat. Whether the confession is admissible, inadmissible due to involuntariness. Confession of co-accused is irrelevant and inadmissible when made before the magistrate who told him that if he made a full confession he would be released. Extrajudicial confession is involuntary, can be relied upon with other evidence. Extrajudicial confession is a weak piece of evidence. Both are true. BR is the correct assertion of A. A voluntary confession is admissible in evidence when made to the magistrate of competent jurisdiction. Which one of the following has not been mentioned as a ground under Section 24 rendering a confession by an accused person is irrelevant? Deceit. A said to B that he has finished his wife forever. Under Indian Evidence Act of the statement amount to confession. Confession caused by inducement, threat, promise when relevant in criminal proceeding by section 24. A commit a crime and goes to police officer. He make a confession, give other information. A is charged with offense. The confession cannot be proved against him because section 25 of the act. Confession before police officer will be provided, will not be proved. In which section of Indian Evidence Act 1882, confession made by police officer is not admissible. Section 25. Whether confession made by police officer while not in custody by a person accused of the offense can be provided against him and is a dash evidence, not admissible evidence. Under which section of Indian Evidence Act confession before a police is not admissible? Section 25. A confession to be inadmissible under section 25 of Evidence Act may related to the same crime or any other crime. Confession recorded by magistrate on oath is inadmissible. A confessional statement made by police is not admissible. A relevant confession will become irrelevant when made to police officer. A statement before the police officer in the course of investigation was that the design was carried out according to plan, but no reference was made by person who is involuntary in murder or to the maker of the statement. Prosecution shall not be allowed to prove the statement but hit by section 25 of Indian Evidence Act. A commit a crime and goes to the police officer. He make a confession and other information. A is in charge with the offense. The confession cannot be proved against him because section 25 of the act. Provision regarding the confession made to the police officer is given in section dash of Indian Evidence Act, section 25. A confession to an admissible under section 25 of the act may related to the same crime which the offender is in charge. Confession of the accused is irrelevant and inadmissible when before a magistrate who told him that if he made full confession he would be released. A voluntary confession is admissible in evidence when made to the magistrate having competent jurisdiction. Under which section of Evidence Act confession before a magistrate is relevant? Section 26. The term police custody used in section 26 of Indian Evidence Act means which one of the following? Some kind of surveillance restriction over the accused person by the police. The term judicial confession means it is made before a magistrate. A confession made in a police custody is admissible under section 26 of Evidence Act if made in the presence of the magistrate. A confession made by a person while in the custody is inadmissible because of section 26 of Evidence Act. What is the meaning of retracted confession? Confession which is subsequently released. A confession is inadmissible if it is made by the accused to the doctor while he is in the custody of the police officer. Palvinder Kaur vs. State of Punjab is related to which one of the following? Confession. For recording a confession, the magistrate should inform such person that he is not bound to make confession. A confession by accused made while in the police custody be proved against him only when made in the immediate presence of a judicial magistrate. A voluntary confession is admissible in evidence to magistrate having competent jurisdiction. A confession made by the accused person is relevant if it is made while he is in custody of police officer and if made in the immediate presence of the magistrate. Under which section of Indian Evidence Act confession before magistrate is relevant? Section 26. Confession before police officer will be proved. Confession made by a person in police shall not be proved as against the person under which section of the Evidence Act? Section 26. Extrajudicial confession means confession made by to the police officer, to the doctor. A confession is admissible if it is made by the accused to the spiritual advisor under the inducement of goods of his soul. In certain cases, corroboration of confession is necessary. One is correct or reason is wrong. An accused make a confession to the superintendent of police (SP). In this case, the confession made by A is not admissible in Evidence Act against A. Evidence against A. Confession made while in custody of police are inadmissible. Confession made by police officer in immediate presence of magistrate is admissible if cooperated by the magistrate. In which one of the following cases constitutionality of section 27 was challenged for the violation of Article 20 Clause 3 of the Constitution? State of Bombay versus Kathi Kalu. In which one of the following case it was held that section 27 of Indian Evidence Act 1872 is an exception to the section 24, 25, 26 Inayatullah versus State of Madras, Maharashtra. Section 27 of Indian Evidence Act applies to when the person give information is an accused and is in the police custody. Which section of Indian Evidence Act deal with doctrine of confirmation by subsequent fact? Section 27. Confessional statement of the accused in custody when admissible leading to the discovery of fact. The mandatory requirement of section 27 of Indian Evidence Act is that the accused must be in the police custody. Under section 27 of Indian Evidence Act, in respect of confessional statement, so much information as to the related distinctly to the fact discovered in the consequence of information received from the person accused may be proved against him. Person giving such information must be an accused of an offense. Section 27 of Indian Evidence Act applies to the discovery of some fact which the police had not previously learned from other sources and was first derived from information given by the accused. Under Section 27 of Indian Evidence Act, discovery of fact include Object found, the place from where it is produced. An accused in the police custody informed to the station house officer that key by which he opened the safe and committed a theft and kept by him in the partition of his house. To what extent this information can be proved? For keeping the key in possession to the house. Under Section 27 of Indian Evidence Act, the fact discovered means the knowledge of the accused as to the object of the place. During the course of trial of a murder case, which one of the following may be proved? Recovery of weapon of the offense on the basis of a statement made by accused during the investigation of another case. Which section of Indian Evidence Act reflects the doctrine of confirmation by subsequent conduct? Section 27. Fill in the blanks. When the question is whether a man is alive or dead, and so that he was alive within the burden of proving that he is dead, is one of the person who have framed it 30 years. What is not necessary ingredient of attracting the provision of Section 27 of Indian Evidence Act, male or female? Which one is necessary element? The person must be accused of an offense. He should give information, discovery of fact and consequence of information. Section 27 of Indian Evidence Act applies to when the person giving information in an accused and in the police custody. Section 27 of Indian Evidence is based on doctrine of confirmation by subsequent event. Recovery made by police officer under Section 27 of Indian Evidence Act, recording of a formal arrest of the accused is legal. Basic idea embedded in Section 27 of Indian Evidence Act is the doctrine of confirmation by subsequent conduct. The constitutionality of this section of Indian Evidence Act was challenged in the case of State of UP versus Divman Upadhyay for the violation of Article 14 of the Constitution, Section 27. The question is whether A committed a crime in Kolkata on certain day. In the answer to the question, which one of the following fact is relevant? A was out that day at Mumbai. If the confession is otherwise relevant, in which situation it became irrelevant? None of you. A person after committing a crime confess while intoxicated the commission of crime. Under Indian Evidence Act, the confession is relevant and admissible in Section 29. A confession by a accused can be used against co-accused under Section 30 of Evidence Act B only as corroborative evidence. Confession of a co-accused not required to be an oath and cannot be tested in cross-examination. If no evidence within the meaning of Section 3 of Indian Evidence Act not be the foundation of conviction, the only limited use which can be made of a confession of co-accused by which furnish the additional reason of believing such other evidence exists. It is very weak type of evidence and much weaker even than the evidence of an approver, under which condition a court may take into the consideration of confession of one accused against himself to the another person if they are tried jointly for the same offense. The illustration of A and B are jointly tried for the murder of C. It proved that A and B and I murdered C related. Section 30 of Indian Evidence Act. Under Indian Evidence Act, a statement made by co-accused at the time of commission of offence is admission under Section 6, which is correct in the proposition of law of evidence. In case of joint trial of several persons, when confession statement made by one of them affecting himself and other is proved, the court has power to consider such confession against such other person as well as against the maker of such confession. Under Indian Evidence Act, confession of one accused is admissible in evidence against co-accused if they are tried jointly for the same offense. A is tried for the murder of C. There is evidence to show that C was murdered and A and B, that B said A and I murdered C. As against A, this evidence is not to be taken in consideration of A and B and not being jointly tried. Confession of accused is admissible against other co-accused under Section 30 of Indian Evidence Act. Under Section 30 of Indian Evidence Act, confession of one accused is admissible evidence against co-accused if they are tried jointly for the same offense. Under which condition a court may take into consideration the confession of one accused against himself to the another person if they are tried jointly for the same offense. What is the evidentiary value of confession of co-accused implicating him as well as his other non-confessing co-accused? Such confession is relevant against all of the co-accused. A and B jointly tried for the murder of C. It is proved that A said B and I murdered C. What is the nature of confession against B? Only corroborated evidence. Confessional statement made by accused may be admissible against other accused are being jointly tried for the same offense. Confession of one accused is admissible against co-accused if they are tried jointly for the same offense. Ravindra Kumar Pal at the rate Dara Singh versus Republic of India is a famous case coming under Section 13 of Indian Evidence Act as well as known as Graham Strain murder case. Admission may be operate as estoppel. The correct position of law of evidence is admission is not conclusive proof of matter admitted, but they may be operate as estoppel under the circumstances. Admission are not conclusive proof of matter admitted but operate as estoppel. Admission is not conclusive proof of matter admitted, but they may be operated as estoppel. Section 31 of Indian Evidence Act is estoppel. Which of the statement is true? Admission of a party is may be operate as estoppel. Admission are may be operate as estoppel. Section 31 of Indian Evidence Act, the admission is not conclusive proof of matter admitted, but they operate as estoppel. Admission is a not conclusive proof but may operate as estoppel. Which one of the following statement is true? Admission are not conclusive proof of matter, but they may operate as certain provisions of Indian Evidence Act. X and Y are jointly tried for murder of Z. It provides that X said Y, I murdered Z. The confession of Z is may be against into the consideration of Y. The principle on which the dying declaration is admissible under Indian Evidence Act indicated in legal maxim nemo mortuus pre mesometri mentri. Case of Pakla Narayan Swami versus King Emperor is related to dying declaration. Indian Evidence Act exception of hearsay rule is section 32 to 33. A dying declaration stand on the footing as against the piece of evidence, has subjected to very close scrutiny for reliability. Dying declaration may be made to doctor, magistrate, any other person. Provisions of section 32 clause 1 of Indian Evidence Act is attracted where with what is not true. Venerable statement is not admissible. A dying declaration can form sole basis of conviction without the corroboration by independent evidence. To be admissible, a dying declaration must be made to any person, a doctor, magistrate, friend, or relative. Which one of the following statement is correct? Section 152 of Indian Evidence Act 1872. Which one of the following statement is correct? A dying declaration is substantive evidence. Which one of the following statement is correct? A dying declaration made under section 32 of Indian Evidence Act 1872 subject to the control of section 158 of Indian Evidence Act. Which one of the following section of Indian Evidence Act provide exception to the rule of hearsay is not admissible? Section 32. An Indian Evidence Act, the dying declaration is not admissible if the person making the statement was not competent in the opinion of the court. The question before the court is the relevant fact of wreck of ship, protest made by the captain, attendance cannot be produced. Evidentiary value of dying declaration, a conviction made even without corroboration. Which one of the following is true? Dying declaration is admissible, may be made before a magistrate to the police officer. In which one of the following dying declaration are admissible? Both in civil case, civil and criminal proceeding. For the admissibility of dying declaration, it is not necessary that the statement, the person making the statement must be under exception of the death. In which section doctrine of dying declaration is found? Section 32. Dying declaration is admissible when both civil as well as criminal proceeding. Under section 32 of Indian Evidence Act, a person who is dead to be admissible must relate to the cause of his own death. A dying declaration is admissible, may be made either before the magistrate, police officer, or doctor, or in private person. The form of dying declaration is immaterial. Dying declaration as to the admissible under Indian Evidence Act must be made before magistrate, police officer, doctor, or private person. The dying declaration to the admissible in evidence, which one of the following is not necessary? That the person making the statement was under the exception of death. Under section 32 of Indian Evidence Act, the statement of person who is dead is to be admissible must be related to the cause of his own death. A dying declaration can form a sole basis of conviction without the corroboration of independent evidence. Exceptions of hearsay rule are provided in the Indian Evidence Act under section 32 and 33. The maxim nemo mortuis presumptuis mentis is applicable to the Indian Evidence Act under section 32 clause 1. Section 32 of Indian Evidence Act does not speak which one of the following person who is unwillingly to give evidence. Necessary rule regarding the admissibility of evidence contained in Section 32 of Indian Evidence Act. Necessity rule of the admissible of evidence is contained in Section 32 of Evidence Act. In which one of the following case statement need not to be writing? Dying declaration. A woman is raped and marked statement that A raped her. 2 days later she commits suicide. Her statement regarding tape is admissible as a dying declaration only if there is some evidence directly connection to her death with the incident of rape. A dying declaration under section 32 of Indian Evidence Act is admissible evidence even if it is made by a police officer. The essential condition of dying declaration to the relevant include the statement made by the person as to the cause of his death, statement made by the person as to any of the circumstances of the transaction which resulted to the death. A dying declaration is admissible in evidence. It is admissibility found upon the principle of necessity. The case of Paklanarayan Swamy versus King Emperor is related to dying declaration. Under Indian Evidence Act 18A72, a declaration made in the course of business is admissible under Section 32 Clause 2. Kausal Rao versus State of Bombay 1958 is related to which one of the following topic of Evidence Act? Dying declaration. Under Indian Evidence Act, which one of the following is not essential condition for admissibility of dying declaration? A person making evidence must be under exception of death at the time of making such statement. Exception to the admissibility of hearsay evidence is Section 32 of Evidence Act. Under Section 32 of Indian Evidence Act, a statement by a person who is dead is relevant if it relates to the cause of his own death, which is not correct and admissible as dying declaration under Section 32 Clause 1 of Indian Evidence Act. It is not necessary that cause of death must be in question. Which one of the following statement is not correct? When the relative of the declarant are present during dying declaration would be relevant. Necessity rule of admissibility of evidence contained in Section 32 of Indian Evidence Act. A dying declaration under Section 32 of Indian Evidence Act is admissible in evidence only when it reduced in writing. Which one of the following is not essential condition of admissibility of dying declaration? A person making a statement under the exception of death at the time he made the statement. A dying declaration can form a sole basis of conviction without the corroboration by independent evidence. Which one of the following statement is true? A dying declaration to be admissible may be made before a magistrate, police officer or doctor. In which one of among the following cases, Supreme Court of India said that if it is not an absolute rule of law that dying declaration must be corroborated with other evidence before it can be acted. Sarad Breed Chand Sardha versus State of Sarad Badhai Chand Sardha versus State of Maharashtra. Which can when can a person prove his own statement constituting admission, or it may be proved on his behalf? When it is relevant as a dying declaration. The case of Pakla Narayan Swami versus King Emperor is related to dying declaration. A dying declaration stands on the same footing as any other piece of evidence, has to be substituted to very close scrutiny for reliability. Which one of the following cases is directly related to Section 32 Clause 1 of Indian Evidence Act? Pakla Narayan Swami versus King Emperor. Dying declaration is admissible only in criminal proceeding, only in civil proceeding. Both A and B. A wishes to prove a dying declaration by B. A must prove B death. Which section of Indian Evidence Act provide that? Section 104. Under Indian Evidence Act, dying declaration contained in Section 32.